circuit. I don't believe you have to, but I don't think that cases from other circuits are considered precedents in the same way. If there's nothing that you can cite in your own circuit, I think you can cite to cases in different circuits as maybe guiding or whatever, but I don't think it's considered as strong as being able to cite to your own federal circuit. This action is before the court on the motion of the United States for a protective order. The motion was initially referred to the magistrate judge, but was then referred to the undersigned, or the senior district judge, as an appeal from his determination for the reasons set forth below after conducting a de novo review of the ruling. So I believe that de novo means you're starting from nothing and doing a legal review of it? Yes. Okay. So you're not taking into account like, well, the lower court said this, so we kind of agree. You're starting fresh, basically. You're just doing your own legal review. De novo might mean new or something. I don't know. Whatever. After conducting a de novo review of the ruling of the magistrate judge, the court will reverse that ruling and will grant the relief sought by the defendants. The United States for a protective order. Okay, so all right. Background. Plaintiff Eva Wheels initiated this Title VII action, alleging that she was sexually harassed during her tenure as a nurse practitioner at the Coast Guard's Aviation Training Center in Mobile, Alabama. In particular, she alleges that she was harassed by Ken Armstrong and Charles Skeers, and that she made the harassment known to Lieutenant Eric Starn. Starn served the Coast Guard as a supervisor at the Aviation Training Center. He is not a party to this action and is not accused of actual harassment, but he is concededly an important witness in this matter by virtue of his supervisory position. He denies the plaintiff reported the alleged harassment to him. Jeanette Waldrop was, during the relevant times, a co-employee of the plaintiff under the common supervision of Starn. Her testimony in this case is expected to corroborate Starn's and is expected to, by all involved, to be very unfavorable to the plaintiff's case. Like Starn, she is not a party to this action. On March 31st, 1998, okay, hold on real quick. Parties are only people listed as defendants and plaintiffs, correct? Like a witness, I believe, is not a party to a case, right? Kafka or... Where did the 3 lawyer people go in chat? Fuck you guys. Oh, thank you. Oh, the Cornell one is good too. In legal parlance, a party is a person or entity who takes part in a legal transaction. For example, a person with an immediate interest in an agreement or deed, or a plaintiff or defendant in a lawsuit. A third party is, okay, parties in a lawsuit are the plaintiff or petitioner bringing the case, or the defendant or respondent defending us. Okay, that's what I thought. Okay. Witnesses are not considered parties to a case. All right, just making sure on that. On March 31st, 1998, the deposition of Starn was commenced. It did not proceed for any great length of time. A short time into the deposition, the following exchange took place by Mr. Mosley. Did you ever go to Jeanette Waldrop's home on Vista Bonita Drive in Mobile, I think? Yes, I've been there. Have you ever spent the night at Jeanette Waldrop's? Mr. Sawyer, objection. Have you ever spent the night at Jeanette Waldrop's home? Mr. Sawyer, objection. Don't answer that. For the record, I'm instructing the witness not to answer. It's not relevant, and there's no need to get into that. I don't believe you can tell a witness to avoid answering because of relevancy, but okay, I don't know. It certainly is relevant. Well, I'm instructing the witness not to answer. Well, we'll have to go to the judge. Well, then go to the judge. The parties then held a telephone conference with the magistrate judge. The magistrate judge ruled the question propounded by Mr. Mosley was proper and that the witness must answer. Counsel for the federal defendants immediately announced his intention to seek relief from the district court and terminated the deposition. The parties have fully briefed the issue before the court, and the issues joined are ripe for adjudication. Ripe, I believe, in this sense means that the appropriate channels have been exhausted, so now they're looking at a higher level court, I guess, to figure out the answer to this. Legal standards, generally speaking, federal rules of civil procedure grant a party seeking discovery a very wide path down which he may foray in search of all information favorable to his case. In the absence of a court order, information is deemed discoverable if it is relevant to the subject matter involved in the pending action. The information sought need not be admissible at the trial if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. However, when a party's discovery efforts are more invasive than necessary, the rules also provide a remedy. On matters relating to a deposition, the court may make an order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following. And that certain matters not be inquired into, or that the scope of the disclosure or discovery be limited to certain matters. This makes sense, right? So imagine you have the right, or imagine you get to do a deposition on somebody's friend who has information about some way that they were wronged by a defendant in a case. And as you're talking to that friend, you're like, isn't it true that you sucked and were a prostitute and gambled and cheated on your husband? And it's like, this has no relevancy to this case at all. And two, this is incredibly invasive and you don't need access to this information, right? So it makes sense that there would be rules that would protect, say, witnesses' rights when it comes to answering questions and being witness to a case, right? That makes sense that that would exist. They're not even parties to the case, right? Setting federal rules of civil procedure 26C. On a motion invoking that rule, this court is called upon to undertake a careful balancing of all relevant matters. The Court of Appeals for the Seventh Circuit has stated, so here they're talking about a different circuit, right? So they can talk about what other circuits have ruled. A motion under Rule 26C to limit discovery requires the district judge to compare the hardship to the party against whom discovery is sought, if discovery is allowed, with the hardship to the party seeking discovery, if discovery is denied. He must consider the nature of the hardship as well as its magnitude, and thus give more weight to interests that have a distinctively social value than to purely private interests. And he must consider the possibility of reconciling the competing interest through a carefully crafted protective order. So what this means, and people seem to forget this, especially Pixie and everybody involved, because to them all of this is just a giant fucking meme post on the internet. But when it comes to big boy court, when we're in court, we're not talking about like internet screen names and Discord DMs and all of this like cutesy shit. Now we're in a court where there is a public interest for justice to, prevail, that the public has an interest in knowing what is involved in this process. They have an interest. There's a public interest in seeing who are the witnesses. There's a public interest in seeing who is the plaintiff, who's the defendant, what are the questions being asked, what are the filings. All of us have an interest in this because we'd like to be able to cite to it. If it's a strong case, you want to be able to reference it. The credibilities of all these people are on the line. Sometimes there are big boy penalties. Sometimes this stuff could even be used later on for criminal stuff, depending on how badly a case could go or what comes out or whatever. So we all have an interest in this. However, there also are privacy interests for some of the people involved. Some of the information can be humiliating, especially when you're talking about sexual stuff, especially if you're talking about minors, especially if you're talking about stuff that might not be directly related to the case. So what this is saying is the judge, must consider the nature of the hardship, meaning how much is it going to fuck over somebody seeking information to validate their claims, right? He must consider the nature of the hardship as well as its magnitude, right? How big of an impact will this have on the case? And thus give more weight to interests that have a distinctively social value, meaning you have to give more weight to the public interest, distinctly social value, than to purely private interests. It's not enough to just be like, don't dox my name. I don't want my name to be out there. Then you shouldn't be involved in a court case. These are public matters. These are public proceedings now. These are public filings, right? If you don't, and you want to hide your name, then you have no business. This is not the forum for you. You shouldn't be in the legal forum. You should go somewhere else. That's what Twitlongers and Substacks are for. And you must consider the possibility of reconciling the competing interests through a carefully crafted protective order. A protective order could allow somebody to pursue discovery while still keeping some information private from the public, right? Would be what a protective order might be for. So for instance, proceeding under a pseudonym. Plaintiff in my case is Jane Doe. I know who she is. The public doesn't have access to her name. Now, for a whole bunch of other reasons they do, but that's because plaintiff is but this is the balancing act, I guess, you have to do when you're filing or when you're trying to construct a protective order, right? To state the matter more concretely, this court must balance plaintiff's need to inquire into the sexual conduct between two non-party witnesses against the non-party's legitimate interests in privacy, meaning witnesses for the defense, I guess. If the requested relief is granted, the court must carefully tailor its order so that the plaintiff's access to legitimate areas of discovery under Federal Rule Civil Procedure 26 is curtailed no more than is necessary. Oh, this is blocking. This isn't just for a protective order, though, like to proceed under pseudonym or for filing under seal. This is to block off an entire area of questioning, though, I think. So this is even stronger for what they're going for, or it's a different thing. Discussion. Plaintiff's need for the information sought. Plaintiff seeks to inquire into the possibility of a sexual relationship between Starn and Waldrop for one reason only. She believes that evidence of such a relationship would prove that Waldrop is a biased witness because she would tailor her testimony to maintain the good favor of Starn. The court notes initially that this is a rather attenuated claim of bias that the plaintiff is raising. The worst act or omission of which Starn is accused is that plaintiff reported acts of sexual harassment to him and did not take sufficient actions to stop the harassment. Starn himself is not accused of harassment. Waldrop's worst possible testimony could not, therefore, paint Starn in too unfavorable a light and could not result in his personal liability. On the contrary, Starn has little or nothing to gain personally from Waldrop's most favorable testimony. Therefore, the plaintiff has articulated little or no reason why Waldrop would tailor her testimony to favor Starn or to disfavor the plaintiff. The plaintiff, therefore, will not be greatly prejudiced by a limitation on the discovery that she presently seeks. Plaintiff, therefore, will not be greatly prejudiced by a limitation on the discovery she presently seeks. Okay. So saying that you haven't put forth a good argument to say why you should be allowed to ask these questions, because even if both of these witnesses answer the most favorably possible to you, still doesn't really help your case much. Moreover, what little prejudice the plaintiff will suffer may be curable by stipulation. Counsel for the federal defendants avers that Starn and Waldrop are willing to stipulate to certain facts which plaintiff may be able to use in order to question Waldrop's testimony without probing into the intimate sexual matters of these non-parties' private lives. Defendant's interest in discovering information from which bias might be inferred was mitigated by availability of other evidence from which equivalent inference might be made. Indeed, plaintiff herself does not purport to seek intimate details of Starn and Waldrop's alleged affair. During the telephone conference with the magistrate judge, which was held during Starn's failed deposition, counsel for the plaintiff stated, "The only thing I want to know is if they had an affair, and they can either deny it or not. That's the only thing I want to know. I don't want to know anything about their sex lives. Other than that, they're adults, we're adults, and I'm not going to ask anything like that." Starn deposition at 70. If this is truly all plaintiff wants to know, then the witnesses are apparently willing to agree to as much. Witnesses' interest in privacy. So this is probably especially interesting to us. Against the plaintiff's interest in gathering information to prove her case, discussed supra, does that mean above? Against the plaintiff's interest in gathering information to prove her case, discussed supra, the court must weigh the non-party witness's right to be free from unreasonable inquisition into their private lives. At the outset, the court must express its categorical rejection of the notion, alluded to by the government in footnote 6 of its brief, that any penumbra eminent far enough from the due process clauses of the Constitution to embrace any constitutional right to engage in the alleged acts about which the plaintiff seeks to inquire. Jesus. Penumbra eminent, far enough from the due process clause. Hold on, let me reread this. Okay, at the outset, the court must express its categorical rejection of the notion, alluded to by the government in footnote 6 of its brief, even if eminent far enough from the due process clauses, the Constitution to embrace any constitutional right to engage in the alleged acts about which the plaintiff seeks to inquire. My guess is that the government tried to argue that if it's not like strictly in the due process clause of the Constitution or something, then it doesn't count as being protectable or something, maybe, is my guess. That's my guess, I don't know. Such effusive emanation would be better characterized as unlawful encroachment on the traditional police powers of the several states. The U.S. Connecticut does not have statutes constitutional. A court's holding is in no way based on any constitutional right other than perhaps that fundamental one to be let alone, the most comprehensive of rights, and the right most valued by civilized men. Starn and Waldrop's rights to be let alone are recognized and given expression in federal rules. Okay. Emanate, it's a verb. Penumbrae is plural. Okay. While judicial emanation is to be eschewed, it must be recognized that Starn and Waldrop certainly have legitimate interests in privacy regarding their personal affairs, whether or not the court or the state condones the alleged subject matter of the same. In this litigious age, their interests are heightened given that they are engaged in at least a quasi-military enterprise. Their privacy interests are further bolstered by the fact that neither is a party, neither Starn nor Waldrop is voluntarily involved in this lawsuit. Not voluntarily involved in this lawsuit. And as far as the record shows, neither is guilty, as that term is naturally understood, of any malfeasance by which they invited themselves to be involved in this lawsuit. Balancing of interests. Having fully considered all of the above matters, the court concludes that the witness's interests in maintaining the privacy of their intimate relationships outweighs plaintiff's interest in invading it. Plaintiff essentially seeks to ask Starn and Waldrop whether they have ever engaged in sexual intercourse. She believes that evidence of a sexual relationship with Starn will discredit Waldrop's adverse testimony. As discussed above, the court finds this claim of bias rather weak and the witness's interests in privacy rather strong. Therefore, the court holds there is good cause to limit the scope of the depositions of Starn and Waldrop in order to protect the deponents, meaning people who are doing a deposition, from annoyance, embarrassment, and oppression. Other courts have reached, this is 639, okay, other courts have reached similar conclusions, particularly some of the, in that case, a sex harassment plaintiff sought to depose certain non-parties who were not accused of contributing to the alleged hostile work environment. Defendant Kmart, on behalf of the non-party deponents, sought a protective order that any voluntary romantic conduct or sexual related activities of the witnesses not be inquired into during deposition or other discovery or examination of that particular lawsuit. Court has previously made reference to the cases of Farnsworth v. Procter and Gamble. Oh, is that where they ripped that reference from? They just took it from this when they found it? They are mentioned again as cases which preponderate in favor of this court's decision. This court now turns in its final task of resolving the present appeal. Based on the foregoing balance of interest, the court must carefully craft an order which channels plaintiffs' access to discovery no more than necessary and reconciles the competing interests to the greatest possible extent. In this connection, a distinction must be drawn between the annoyance, embarrassment, and oppression that opponents will suffer merely by virtue of having to answer questions about their sexual lives, and the annoyance, embarrassment, and oppression they would suffer by virtue of the disclosure of that information to third parties not involved in this lawsuit. The court concludes that the plaintiff has no more right to the information sought than anyone else. Accordingly, the opponents should be shielded from the unwarranted intrusion in the first instance. Therefore, Starn and Waldrop will not be required to answer questions regarding their sexual lives, as set forth in greater detail below. Counsel for the government was correct in instructing Starn not to answer the pending question and did not wrongfully terminate his deposition. Damn. Okay, sorry. So coming back here, I'm just curious. Bonnell also overlooks that these protections apply with special force to cases calling for evidence of sexual-related activities, as in the case at bar, C, Wheels versus Human Resources Systems, Inc. Okay. Reversing an order, denying motion for protective order by party on behalf of third-party witnesses regarding sexual conduct. Indeed, the revised Rule 412 of the Federal Rules of Evidence now applies to all types of sexual misconduct cases and expressly extends to third-party witnesses. See Stallnaker and Kmart. Oh, and that case was referenced in here as well against Kmart here. Under these safeguards, courts have held, for example, that third-party testimony about romantic or sexual relationships is highly sensitive in nature, and that disclosure of the witnesses' identities within their communities would expose them potentially to harassment, embarrassment, or stigma. Well, but this case had nothing to do with exposure of identities. This case just had to do with what questions could be asked during a deposition. None of the cases they ever cite ever match anything well, but nature. Okay, Voice of San Diego v. Naval Criminal Investigative Service. I wonder what this case was about, because this seems to be the most relevant one. Within their communities would expose them potentially to harassment, embarrassment. I wonder if this had to do with disclosure of an identity. So they're basically citing a case and just attaching the one cited to it to make their own case look more legit. Yeah, it's kind of like when you Wikipedia an article and then you like just cite all the sources of the above, I guess. Or maybe these are very commonly cited cases in this, although I would be surprised given how little relationship they seem to have to my own case. But regarding side note / journal entries that consist of the descendants or the decadents, the decedents? The fuck is decedent?
Decedent.
Oh, a person who's deceased, who's died. Regarding side note / journal entries that consist of the decedent's note or journal entries, the court has no trouble in concluding that the decedents and their surviving family members have the strongest privacy interests in both the suicide note and the journal entries. The requested side note would intrude not only into the memory of a deceased loved one, but more specifically into the intimate and private relationship between the decedent and her family members. Similarly, the writings of a decedent in the days leading up to her suicide are likely to contain personal information, like entries related to possible ideations and notes apologizing to family members. The decedent and their families have the strongest personal privacy interests in such matters. Third parties also have strong privacy interests in the journal entries describing their relationship with the decedent. Disclosure of these entries reasonably could allow their identification within their smaller communities, subjecting them to unwarranted pain, embarrassment, or stigma, either from the content of the comments or the connection to the suicide investigation. And they cited that as under these safeguards, courts have held, for example, that third-party testimony about, quote, romantic or sexual relationships, end quote, is highly sensitive in nature and that their disclosure of the witness identities, quote, within their communities would expose them potentially to harassment, embarrassment, or stigma, end quote. This was about diary. Wait, is there another quote in this that I'm missing? This has nothing to do with romantic shit. This has to do with fucking shit written in a diary about a guy that killed himself. What the Am I missing something? Was there something else they're citing to that I'm missing? Potentially to harassment. Control F. Potentially to... Oh, wait, hold on. Maybe this isn't the right quote. Maybe there's something else? No results found. They fucked up quotes before. Did they fuck their quote up? Is this not a real quote? Did they just make this up? Quote. Within their communities would expose them to potentially to harassment, embarrassment, or stigma. Control F, stigma. Disclosure to these entries reasonably could allow their identification within their smaller communities, subjecting them to unwarranted pain, embarrassment, or stigma. Would expose them potentially to harassment, embarrassment, or stigma. Do they have a translated document or something? Or what's happening here? Is there another quote that's incredibly similar but uses a different adjective instead of harassment, unwarranted pain? 753F. Is there a way to see like the page that this would have been published on? Or they're trying to make it fit for this case. Yeah, but it clearly doesn't. Also, I would argue this isn't even misleading. This is a lie. They're saying under these safeguards, courts have held, for example, you're saying third-party testimony about, quote, romantic or sexual relationships, end quote, is highly sensitive in nature, and the disclosure of the witness identities, quote, within their communities would expose them potentially to harassment, embarrassment, or stigma, end quote. But this last thing, I don't think has to do with romantic or sexual relationships. It has to do with entries in a diary from a person who fucking killed themselves. Maybe they talk about romantic parts and some other here? Oh, they pull it from a later quote. Hold on. This part down, romantic. They pull it. Okay, next, the court relates that defendants have categorized 5 of the items in the Vaughn Index as pertaining to intimate or sexual information, which includes information about or conveyed during the course of a decedent or a third-party witness's intimate, romantic, or sexual relationship. Within these 5 items, defendants have asserted privacy interests on behalf of the deceased service members, their families, their parties. These are dead people. Court finds that, as discussed above, the fact of death diminishes but does not eliminate an individual's privacy interests. Well, the court is unaware of a Ninth Circuit decision expressly holding that deceased individuals have privacy interests and their own criminal records. The court is mindful that the mention of an individual's name in a law enforcement file will engender comment and speculation and carries a stigmatizing connotation. Additionally, one court has concluded that the deceased defendant never convicted of the crime. In light of these guiding principles and the absence of arguments or evidence from plaintiff that the law enforcement contacts here already know to the general public, the court agrees with the defendants that disclosure of these records can implicate measurable privacy interests that decedents retain in their criminal histories and prior encounters with law enforcement. Jesus. Okay. These must be I wonder if there's like ChatGPT summaries for cases. I wonder if that's where they get these from. Finally, there's no support to Bunnell's insistence that the plaintiff failed to meet her evidentiary burden to show good cause, as other courts have concluded under similar circumstances. The third-party witnesses wish to remain anonymous based solely on their representations to that effect to the moving party. See Alaska Actions on Toxics versus Aurora Energy. Rejecting defendants' standing argument and observing that the anonymous individuals here have indicated to plaintiff's representative that they wish to remain anonymous, noting that other courts have entered protective orders barring the disclosure of the individuals submitted information anonymously and protecting the identities of individuals who would like to be subjected to the rest of the submitted information anonymously. Well, these are about specific witnesses coming forward testifying to specific and explicit information. I'm okay. I'm not going to look up all of these. I guess if I look up this, it also is something that has absolutely nothing to do with the type of case here, but tellingly, none of Bunnell's cited cases involve allegations of sexual misconduct, such as cyber harassment. Yeah, because you guys haven't even put anything in the record to show any evidence of me engaging in cyber harassment. What the fuck? Against plaintiff? As such, each case Bunnell relies on is inopposite and unpersuasive. Bunnell's citations to the line of cases declining to permit anonymity cuts against his position, given that this court has already found that this is that exceptional case where the plaintiff may proceed under a fictitious name. It's not an exceptional case where the plaintiff may do it. The statute literally carves out proceeding under a protective order, and her witnesses may submit declarations under seal without public disclosure of their identity. Where is that that's not in the statute. See Doe v. Frank. Case involving allegation or discrimination on the basis of alcoholism. Were all the witnesses anonymous in this one? Doe v. Frank. It was 92, so it's not the same law, but was there cyber harassment in 1992? I cited at DE 92 at 3, 5, and 7. Let's see. Opinion of the court. We also see no error in how the court addressed Doe's concerns over alleged fear of prosecution, the third step 1 factor. District court found that any sexual intention related to Doe's drug use. Moving to the second factor, potential selection. We kind of say the district court abused its discretion. Doe ends by cautioning that affirming the district court would likely result in no Title IX litigant being able to proceed anonymously. Citing a case from the First Circuit he believes supports reversal here, but we agree with the First Circuit that the confidentiality of a Title IX disciplinary proceeding may sometimes, but not always, furnish grounds for finding an exceptional case warranting pseudonymity. As shown here, the district courts in our circuit are more than capable of balancing plaintiff's privacy interests against constitutional rights to access to judicial proceedings. And district court thoroughly reviewed the circumstances presented to it and made no clear error in judgment when denying Doe's motion. The order denying the motion to proceed anonymously is therefore affirmed. The order denying the motion. Wait, is this a loss that they're citing? Am I misunderstanding this? Wait, hold on. Wait. Bro, I don't want to read anywhere this. Wait, hold on. I must be misunderstanding. Tellingly, none of Bunnell's cases are Bunnell's citations to the lines of cases declining to permit anonymity cuts against his position, given that this court has already found that this is the exceptional case where the plaintiff may proceed under a fictitious name, and her witnesses may submit declarations under seal without public disclosure of their identity. See Doe v. Frank. But in Doe v. Frank, the order denying the motion to proceed anonymously is affirmed. They lost that motion. So why would you cite the argument here? Doe hasn't demonstrated the district court abused its discretion when it found that any alleged social stigma Doe will face didn't outweigh the presumption that his proceeding should be a public one. Put simply, he does not cite any evidence of these harms, and instead only asserts in briefing that they are nearly certain to occur. He says, noting that the plaintiff offered several documentary exhibits to bolster their assertions that they might be subject to retaliatory harassment or violence if their identities were publicly revealed, affirming denial of motion to proceed anonymously even where 3 plaintiffs submitted affidavits in support of the alleged harms. This was, and they were citing here, affirming the denial of motion to proceed anonymously, even where 3 plaintiffs submitted affidavits in support of the alleged harms. But what's, did they just look up like all the laws or all the lawsuits that were denying or reversing their and then try to cite them as arguments for their own? They are claiming that the court has found that their case was that exceptional case, unlike the cited one. But exceptional how? What are they citing to in the docket where they said this is an exceptional case? They applied to proceed under pseudonym because that's explicitly granted by the statute. The statute says nothing about your witnesses proceeding under pseudonym, and we didn't even oppose that that filing. So when did the court find, where is this quote exceptional case coming from? What is the name of this stupid fucking law? It's not a stupid law, I shouldn't say that. Protection, Transmission, Images Act. What is it? What is the... Read the bonus meme in that message. Read footnote 5 in plaintiff's doc. 5. At no point has Bonnell disputed that he threatened plaintiff and her witnesses with physical harm in retaliation to their allegations and testimony in this action. Excuse me, what? What? There are 3 witnesses to this case. When have I publicly threatened physical harm to any of these people? What? Or that he publicly harassed and ridiculed plaintiff's legal team. Yes, I am publicly ridiculing you. Harassment? What is it, harassment to read your fucking filings and make fun of them? In light of the standard language of plaintiff's proposed protective order, there can be no explanation for Bonnell's objections there too, other than that Bonnell intends to continue to threaten and harass plaintiff, her fact witnesses, and her legal team. Oh my fucking God, dude. Didn't you say some crap about Gesticle? First of all, that wasn't a private interview to Willie Mack, number 1. I didn't publish that. Number 2, Gesticle's not a witness to this case. Number 3, this is plaintiff and her witnesses. Did they even formally accuse you of that? Well, they throw it in all their fun. Like, this is, like, I don't even want to, like, participate in this. Like, this just feels stupid. Is this... I'm probably gonna send a big email asking about it. Because, like, this is just, they're posting. Like, this is so dumb. I've got to pay $20,000 to respond to this motion while they make shit up with ChatGPT and post at me like a bunch of people that shouldn't even be allowed to appear in a fucking federal court, like, let alone try a case like this. They clearly have no experience in this realm, like, in anything. Like, this is so unhinged. Every single case I've looked up either doesn't support their claim or cuts against them in the exact opposite. In this one motion, that doesn't include all the other random shit that I've looked at. For equally unpersuasive are Bonnell's remaining case citations, as none involved and now what are they focusing on our citations now because they're mad that I called them out on their citations? This involved different circumstances, whether anonymous affidavits were sufficient to support the plaintiff's trade secrets claim in summary judgment proceedings. By contrast, it is well settled that particularly in sexual harassment and other sexual misconduct cases, it is entirely proper and common for a plaintiff to rely on confidential witnesses. Eckhart vs. Fox News Lawsuit, LLC. I wonder what this one says. Fuck me. Let's see what they say here. Yeah, you can't put things in quotes that aren't being quoted from somewhere. I don't know where that, quote, exceptional case comes from. And they don't source anything on the docket where that filing would say, quote, exceptional case, end quote. I want to know where this quote comes from. I'm very interested. Wait, it was in here. Entirely proper and common. Are they... This is not correct, is it? Wait. It is entirely proper and common for a plaintiff to rely on confidential witnesses, and they cite a case, but it looks like this quote is not from this case, it's from another case. Is that... am I reading this right? By contrast, it is well settled that, particularly in sexual harassment and other sexual misconduct cases, it is, quote, entirely proper and common for a plaintiff to rely on confidential witnesses, end quote. The case being cited is Eckhart v. Fox News Network. And then I'm looking up this case of Eckhart v. Fox News Network, and then I'm looking for the quote, entirely proper. That quote is not from this case, though. That's a quote that they quote from another case. Plumbers and Pipe Lifters Local Union. Henry urges the court to conclude that Eckhart abused the judicial process by including allegations by several anonymous women in her complaint, including one that has since been retracted in part. Blah, blah, blah. Regarding the anonymity of these accusers, the court finds no ground for sanctions, for it is entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint. With respect to the allegations that have been retracted, the court notes that the veracity of those allegations is a question of fact that remains unresolved. let's see, sanctions. So these were for asking for sanctions. Henry court to sanction Eckhart and her counsel pursuant to its inherent authority. As Henry rightly notes, federal courts possess certain inherent powers, including the ability to fashion. Okay, Henry urges the court to include that they abuse just browsed by including allegations by several anonymous women or complaint, including one that has been retracted in part. Henry regarding the anonymity of these accusers, court finds no ground for sanctions, for it is entirely proper and common for plaintiff to rely on confidential witnesses in a complaint. In a complaint. Does this mean for the court case, or does this mean just for filing the initial complaint? That's what that sounds like. Because plaintiff still purports to have good faith basis to believe the allegations are true, the court cannot conclude at this time the plaintiff's failure to remove them from the complaint upon their retraction is sanctionable. Is sanctionable? Let's look up this case. Fuck me, dude. Oh my God. Where's the quote for this? It is entirely proper and comfortably rely on confidential witnesses in a complaint. Confidential. Okay. What? Confidential witness in a complaint. Where is this quote from? In a complaint. This is for document 80. This must be they're citing from a different, I guess. Bro, I have no idea what filing I would want to look at though. Regarding the anonymity. Okay. Or no, wait, I can't look at their quote. Oh no, wait, I can. This doesn't say, it says 278 FRD 335 341. These are like pages published, but it doesn't say the, oh my God. Am I able to search for, I just want to know what they're even citing here. Entirely proper. That's what we're looking for. Entirely proper. Oh, okay, here we go. In holding that the confidential informant's names in this case are not entitled to work product protection, the court is finally mindful the plaintiff has utilized the confidential informants offensively by attributing extensive factual allegations to the 11 CIs and the SAC. Plaintiff buttressed its complaint, presumably with the goal of protecting it against dismissal. It is, of course, entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint, and attributions to such witnesses may and often are credited, and attributions to such witnesses may and often are credited on motions directed to the pleadings. But once the discovery phase begins, the balance of interest shifts. The priority becomes reciprocal and robust fact gathering as the parties seek to discover relevant information. The parties enter. Okay, so this has to do with it was just for the complaint. This has to do with stuff listed on a complaint, not once we're in the discovery phase and everything. Oh, Jesus. Okay. So they cite a case. God, dude, I'm sorry, I'm done. Okay, this is the last one. All right, I'm done. This is my last. I'm not going for any more of this. This is a waste of time. This is so fucking stupid. So just this, so their sentences. By contrast, it is well settled that, particularly in sexual harassment and other sexual misconduct cases, it is, quote, entirely proper and common for a plaintiff to rely on confidential witnesses. So one, they're citing the wrong case because the lawyer is a fucking hack, okay, who should go back to Puerto Rico and only write there, okay? Number one. Number two, the case that you're citing here isn't talking about particularly in sexual harassment and other sexual misconduct cases. So I don't know why you would be citing it here, okay? Number three, the quote that you're citing from has to do with confidential witnesses on a complaint. Now, they had some confusion in court as well, I know, during our, when I was giving testimony, okay? And the plaintiff seems to be confused that a complaint is the first thing you file to begin proceedings on a lawsuit. A complaint is not just an utterance where somebody's complaining about something. A complaint is an actual thing that means something in court. So can you have confidential interests or confidential witnesses in a complaint? The first thing you file to start a lawsuit seems to be the case that yes, but we're not at the complaint stage. Not only are we not at the complaint stage, the underlying cited case literally says it is, of course, entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint. Now remember, for Pixie's law team, that's the first thing that you file to start a lawsuit. That's the very first thing that you file, okay? And attributions to such witnesses may and often are credited on motions directed to the pleadings. But once the discovery phase begins, that's where we're trading stuff like when you asked me for like interrogatories and then we request like certain like cooperation subpoenas. Now that's the discovery phase. That's what we're in now. We're discovering information about each other to find out what can help our cases, right? Okay. Once the discovery phase begins, the balance of interests shift. So while the interest might have been on your side, now the balance is shifted to my side because we have a thing called civil rights in the United States. The priority becomes reciprocal and robust fact gathering. Robust, okay, meaning the ability to cover a lot of ground. Robust, very, a lot of stuff, fact gathering, as the parties seek to discover relevant evidence, like the names of people that you are alleging are witnesses to your complaint. The parties' interrogatories, you might remember that word because you put it on the page when you asked me for interrogatories and we sent it to you for interrogatories, questions you might answer as the beginning part of discovery. Parties' interrogatories, including interrogatories aimed at helping the propounding party assess which witnesses are most likely to produce or to possess probative admissible evidence, are an integral part of this process. And this doesn't even have to do with keeping these sealed from the public. This just has to do with a confidential witness. This is just retarded. Destiny, they aren't citing the wrong case. You can cite a case that quotes another case. I don't believe you. I don't believe you, and I would need you to show me exact evidence of that being the case written somewhere by somebody. I don't believe you otherwise, because that is retarded if that is the case. In the court's view, where a party has attempted to satisfy the pleading requirements of the PSLRA by showcasing statements from a limited number of confidential witnesses, it may not thereafter refuse to disclose who they are on grounds of work product. Partial disclosure of information protected by the work product doctrine may constitute a waiver, and a party is not permitted to use such doctrines as both a shield and a sword. Just as the attorney-client privilege cannot be used as a shield and sword, neither can a worked product document. Product is like part of the thing that you produce as part of discovery, especially one that does not include an attorney's impression, opinions, or strategies, so just stuff from a witness. This is retarded. I don't know. Their filings read like Norm Finkelstein's book in regards to citations. Norm Finkelstein's, oh yeah, his book's is right. I was gonna say Norm Finkelstein's court case is fine because I think he files those as a, oh no, he doesn't. I was gonna say, I think he files those per se, like he represents himself, but I think he does have a lawyer. I'm assuming you don't want to wait until December for discovery to end and a summary judgment to be issued. Is there anything you can do to speed up or force it? Is it really December? Is that when discovery ends? Me, dude. Then me, I guess. Me in the ass. It's good job. Great one. The problem is you don't want to issue, you don't want to ask for summary judgment prior to that. I think one is because it looks bad to the judge, like you're trying to end it prematurely. And then two, plaintiff has already demonstrated her willingness to blatantly fucking lie and then cover up all of the fucking lies by abusing the court system against me. So it's possible that if we do a summary judgment, that they go ahead and they fabricate another witness to make some shit up in order to keep the case alive for whatever reason. Like here, they're quoting this one case again, Heineke versus Santa Clara, about protecting plaintiffs, but this case also, the filing here was about protecting the defendant, where the defendant filed, right? Or am I thinking, or was that a different, maybe that was another case they filed up here, or they referenced up here. I don't remember now. Did you see how she omitted the last part of the quote? What? Entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint. Oh, they cut out the whole, and attributions to such witnesses may and often are credited meaning their identities are revealed on motions directed to the pleadings, correct? Am I understanding that correctly? They did cut out that part of the quote. It's given leeway by most judges, but it's definitely not standard practice to change the text between the quotation marks. They've done paraphrasing. It's given leeway, not when it's changing. I imagine it might be given leeway as long as you're not changing the meaning of the underlying thing. They are credited as in they are assumed to be true for motions to dismiss. Oh, okay, that makes sense. And that would also explain why the balance changes once you're past the pleading stage, right? They're credited as in when the defendant, the respondent, files a motion to dismiss, all of the statements in the complaint are assumed for purposes of dismissal to be true. The judge doesn't weigh the evidence, they just read it and basically assumes everything to be true. Okay. Blue book question. How to cite when there are 3 levels of quotes? I have a citation that is rather difficult. Case A quotes case B, which quotes case C. I need to cite case A. The text I want to quote looks like this. The court agrees with case B, which stated that blue booking is hard when you have to look up really obscure rules that seem to be purposefully confusing. Case B, quoting case C. 2 questions. How do I write the actual citation? Is it proper for me to cite it like this? Case A, quoting case B, quotes C. How do I deal with the internal quotes? Do I keep all of them? Do I get rid of all of them? Well, I think that this is a fundamentally different question. I don't know whoever's looking at this, if you're looking at this. Like, quoting a case, citing another case, I think is different than quoting a case and just having the quote to that case when the full quote is literally just a quote from another case. I think that's a fundamentally different thing. Do I keep all of them or do I get rid of all of them? I know I'm normally supposed to get rid of quotation marks if it is at the end of a quote, as is the case here. Rule 10.6.3. Only one level of quoting is required, so case A, quoting case B. If the cases are controlling authority, it is probably best to cite the original source where possible. So the original source would be the bottom level case. So if case A is quoting case B, you would just quote case B. Yes, this is correct. Rule 10.6.3. I was like, no, however, then only one level. Thus, the case quotes a case that itself quotes another case. Only one level of quoting or citing parentheticals is necessary. An additional level of parenthetical information may be used. Information conveyed is particularly relevant. She cited it wrong, but it's a legit use of quoting common phrases. Dipshit. Why are you talking about quoting common phrases? We're not writing for your Facebook. Is it possible that she knows that she has lost, so she's literally just trying to rack up your legal expenses? Yes, that is exactly what is happening. And she admits, I would argue, they admit to as much in the transcript, but that's why they moved to seal that transcript, because they know that transcript, at least publicly and legally, I would argue, crucifies the fuck out of them. But that's why they moved to get that sealed so fucking quickly. So you're not able to quote anything from the transcript at all? I mean, I can talk about, like, I reread it, so I remember a lot of funny things in there. The cup of water analogy was fucking hilarious. Yeah, I don't know. What are the repercussions if your transcript got leaked? I don't know, but the thing is that right now, like, our behavior has been perfect. Everything has been above board. So if I were to decide to just break from procedure here and say, okay, I'm just going to read the transcript because these people, it would give them the first legitimate thing to kind of grab onto. Can you repeat the cup of water thing? Well, basically the judge is, in my opinion, I don't want to mischaracterize anything the judge thinks or ascribe any thoughts to him that he may or may not have. Obviously, that's the holy judge, holy magistrate judge. His thoughts are his own. But the impression that I got was that the judge was kind of figuring out through all of the testimony kind of how wacky things were. And I think at one point, Pixie was unwilling to admit to my lawyer that it was her idea to record the videos. I think he asks a couple times and she says no. Her lawyers start screeching and objecting to asked and answered, objection, asked and answered. And then eventually my lawyer starts to read quotes to her saying, well, didn't you literally say this? Didn't you literally say this? Didn't Bono literally respond in the affirmative when you made the request? And then at one point, I believe the judge turns and asks her, he's like, hold on. He's like, was it your idea to record stuff? And then she's like, well, maybe. And then she's like, it's kind of like if you have a glass of water and imagine if somebody is standing there drinking a lot of water and they're like, wow, this is really good water. It's so good. And you're thirsty and you're standing there. And then you're like, well, can I have a glass of water? I would kind of say that they kind of like that they offered the water, even if you were the one who asked for it. It was just like, like, bro, are we being fucking serious right now? It's actually, it is, this whole transcript is insanely fucking wacky. Okay. It is a wacky fucking, the testimony, the court thing that day was fucking wild. Okay. Why is discovery going to last until December? I think that it just takes a while for court cases. Destiny, that's a Kiwi Farms argument. Blab argues you convince girls that recording sex is normal by sending them stuff. Oh, sure. Yeah. They borrow a lot of their arguments from Kiwi Farms. Did I mention the paper shuffling yet? There's a lot of times, where the judge, where opposing counsel on cross, is like asking me like some line of questioning, and it's just so stupid. And at some point, he just picks up his papers and starts going, because I can tell that he's like mind himself on whatever line of questions that he had for me. They're just so stupid. Sorry, hold on. I'm not reading from anything. I just had a recollection of a back and forth in court, but I'm not reading from anything. I was just looking at something totally unrelated. But it was really funny because I remember at some point the judge had asked her, he was like, so when did you first find out about these Google Drive links? Because they're trying to run with the Google Drive argument that they lifted from Kiwi Farms, basically. And at one point, I think the judge is asking her about, when did you first learn about like the Google Drive stuff? And she's like, well, I don't remember this at all, but I think that he sent me stuff relating of him and his wife at the time or whatever. And he was like, well, when did that happen? And she was like, I don't know, but it was before we ever met before. And I think the judge said something like, he's like, wait, so he sent you a video of him and his ex-wife hooking up? And she was like, I believe so, yeah. And then he's like, and that didn't give you pause to think for a moment that you guys were sharing? It was, oh shit, it was some funny shit. Oh my God. And then she tried to roll with the slut argument, where I think she started to say, well, no, Zip, do you remember this? And then she starts being like, well, I heard that they were in an open relationship, so I figured, that, maybe they just were more free or they didn't give a fuck about anything. Oh my God. Okay, sorry. Were they successful in sealing the transcript? No, it's temporarily sealed while the judge rules on it. So cringe. Oh my God, it was so cringe. Okay, so I've been looking into the exceptional case quote, and it's from the Doe v. Frank case from 1992. The ultimate test for permitting a plaintiff to proceed anonymously is whether the plaintiff has a substantial privacy right which outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. It is the exceptional case in which the plaintiff may proceed under a fictitious name. Oh, sure. Although this was in 92 before that one law was made, which literally has a carve-out for people to proceed under a pseudonym. Also, I don't know if this has anything to do with the witnesses, but she's trying to bootstrap her anonymity onto the witnesses. I don't even know if they know what they're asking for. They're trying to, because they're trying to keep stuff from us. They're trying to file stuff anonymously. I don't know if they, I honestly don't know if, I don't know. I know they borrow a lot of those arguments, but Justical was legit reacting to clips directly ripped from Kiwi Farms over and over. Yeah, Justical just pushes. His whole server and then him, they rely on like these one or two quotes or supposedly all the secret information that Justical has but doesn't want to share with Pixie for whatever reason. And then they just like play the same quotes over and over again while he like unhinged and derangedly, because I think he quit his software engineering job I think about 1.5 years ago when he decided that he wanted to become a full-time streamer by leeching off all my content. So he's doing anything he can to remain, to feed that Patreon. He goes through all the arguments for why what I've done is the equivalent of like, he calls it e-rape or digital rape, and it's just like, yeah, it's just, okay, it's retarded.
when we don't have to. At least said, this is like that, and it's my fault. Boom, done. So, like I said, this is just,
Like, this
I don't know what is
isn't
even
good for my
needed.
channel. It's not good for your channel. This, one, it's not good for us as people. I did nothing but love and support you, and these are the ways that you destroyed me. These are the ways that you really took advantage of the situation, and the least you could do, the very least you could do, is simply not talk about it. So when I say that I am beyond fucking pissed that he went and even if he fucking leaked it, still give me the fucking heads up that you just leaked it. Still give me the human decency to not fucking talk about it.
Well, I told I was gonna talk about it.
Give me the decency to process the actual mad shit that was going on, but no. It just wasn't. Literally just wasn't.
Okay, well, it's 50-50, I think, in a relationship, and I give her a heads up, and I asked a timeline of like how long do I have to hold on and tank the internet and tank everybody, and I wasn't getting an answer. I mean, initially I think she wanted to like wait like months and just kind of like smooth it out, whatever, and just wait till like people figure out and just kind of smooth it over. But bro, I can't just fucking keep tanking. I'd be like bro, it's man, guys, I agreed up until yesterday when it's like, dude, I have to say something. I can't fucking, bro, I can't have all this over my head over months. It's gonna ruin my fucking stream and my mood. It's gonna ruin the channel, bro. I like streaming, and having this over my head made streaming less fun. And at one point, I can tank a little bit, but it was too much, bro.
It literally is.
I want to stream and have fun, bro.
And the sad part is, if I do talk about more about it in the future, which I just don't, I don't know right now if I want to. It's very fresh for me. I'm very pissed off. I'm very irritated.
3 hours.
Because, man, when somebody, like, God, when they break promises just over and over and over again, and then you think that this is one that they can finally keep because they fucking tell you that it's an agreement. It is mutually agreed upon. It is an understanding. It is finally a perception lock. Like, you get it. You both get it. And they still just don't fucking get it. And they still don't go with their word. It is fucking disappointing. It's enraging.
I mean, we're entering Destiny level type of content now. This is not only fucking log leaking and analytical fucking dialogue dating. This is literally fucking
the classic,
VOD
you
review.
fight for them, but they're not even in your corner. Narcissist alert. Being human isn't easy.
Okay, come on, man.
Was he and his family close? I already answered that.
Okay, bro.
I'm telling you, the first 2 years, didn't even see any of them, didn't know their names, didn't know anything about them. I swear to God. I think eventually, like, the first person I met was, like, the mom.
My mom is great,
but
man.
When I first met him, he told me he did not want to speak to me. But then all of a sudden, now, all of a sudden, these are the people that have his best interest. And it's a mess. It's a mess. I don't even
Bro, my mom was being the trying to be the referee, okay, as much as she can, okay? But like I said, when my brother got really, really sad, man, she got worried, man. She took more of his side, and yeah, I guess it's wrong, but it's her son. Like, of course she'll be defensive.
I hate that he made me have to be involved with his family as much as they were, because I would never let my family, nor would my family ever step over the lines that him and his family did, ever. And that's when I realized that I would never let my family, nor would my family ever step over the lines that him and his family did, ever. Okay. And that's when I realized that.
Well, I mean, my family,
all the things that I've been through for the last few years simply were all leading up to this point. There was no alternative. There was no, like, better moment. It literally just was what it was. And it is toxic, and there were parts that made me feel like, damn, is this narcissism? Like, I don't know how to explain it.
I don't know what part of narcissism. I don't get it. What it was narcissism about anything?
Child trauma from ex side, pretty fucked up. Yeah, and you know who's the reason for all of this being talked about? Felix, because I begged him not to fucking put me in a position where I had to talk about any of it. None of it.
Okay, bro. Okay, I mean, I don't want to get mad at her, but it's like taking a book, whatever, and I said what the book is about, and I move on. But then she's opening all the pages, going all through the chapters, and going through every line. Like, it's not. I
don't want there to be information out there. I don't want to fucking talk about it. I don't want your fucking juicers thinking that they have any answers. I don't want it. Leave me the fuck alone. Leave me alone for once. But you're just making it worse? No. Like I said, I didn't want any of it. I didn't want. I can show you guys hours and days of me literally in between shit camp events yesterday, the day before. Don't do it. Don't involve me in it. I don't want anything to do with it. Chav, thank you so much for the gift of 50. Your channel doesn't need it to survive. Your channel doesn't need it to grow. It's not going to hinder your channel in any way if you don't do it. But here's all the ways that it's.
Well, I need to grow as a person. I have to move on. I don't know what to tell you. And guys, I was on the edge about doing it. It's why I threw it like 3 times, and then it got
me if you do.
It got too much because for me it's all about finding. Whenever there's a lot of clouds, it's about finding that one sun ray, right? And I kept asking, when or how? What's my timeline here for moving on? And it just felt to me like I couldn't find a sun ray of like, oh, when is this gonna happen? When will I be able to move on in my life and just get it out and just say, okay, now we're doing other stuff. I couldn't find a fucking sun ray. Okay, I couldn't find, and after all the dog shit, there was more clouds and more clouds. I made my own sun ray, and boom.
Do it.
Yeah, it's selfish. Okay,
Did it.
but I thought if I take the blame and I say it's my fault, and I say, yo, it's my fault, we can move on or whatever, that it would have been smoothed over and we're chilling. That was my thinking was that. My thing was simple. It was okay. Well, boom. I'll take the blame. I'll say it's my fault, and boom, we move on. But
You said you were on good terms. No, of course he said whatever the fuck he said. Because again, none of it should have been talked about at all. None of it. No one's ever gonna get both sides ever.
well,
That's the fucking issue. I don't want you guys to attack him on my behalf whatsoever. I don't even want you guys to fucking share my point of view to him. He fucking knows because we talked about it for weeks. For weeks. He knows where I stand. He knows how I felt. He knows what my concerns were. He simply chose not to fucking abide by what was best for both of us.
I mean, both of us, I don't know. Dude.
Yes, he did.
I have so much on my mind and not be able to fucking move on with my life and not be able to whatever. That's not us, man. I am also one person. Like, bro, I am also a person. And my needs are also an issue, my brother. Okay, how long do I have to tank this for?
Say much.
How long do I have to tank for?
That his family gave me the short end of the stick. The fact that he even told you guys that things were his
I was already hard tanking everything. How long did I have to do that for, man?
He should have done better. That is him talking about it. Why do you feel the need to defend him for dear life? You don't have to defend him. You don't have to defend me. I am simply talking about it because now that shit's already out there, I'm fucking pissed. Asked him not to do it. Expressed my concerns. None of it. Literally none of it would have been detrimental to his very successful channel to not talk about it. Now, had it been like, oh, Sam, like us breaking up, that's gonna change the whole dynamic of my channel. Like I'm gonna, if I don't tell people, like, oh, that's gonna make me lose so many viewers. That's gonna make me lose so many subs if I don't talk about it. But that's not it. That's not it.
I never said that.
If he had any way to express to me like, oh, I have to release the information because if I don't release the information, then my channel's gonna suffer and I'm gonna lose my whole career, I would be like, yeah, you know what, you're right. You make sense. You should go talk about it.
That's nothing I did.
But actually, it's better for his channel and mine if he doesn't talk about it. So why the fuck did he feel so strongly to need to talk about it?
Well,
to feed parasocial viewers, to have a little bit.
Okay, well, I mean, she probably didn't have the comments on Reddit or whatever, and all of it. It's, dude, I think everybody can agree it got really heavy. I think, listen, I don't like to blame other things, okay? But it comes to a point where, dude, the cloud was really fucking heavy. That is a heavy ass cloud. It was never ending.
More
bro,
public,
like, come on, man.
Like rep? What is it when like?
Bro.
Like people called it his ult. That's basically what it was. It was the ult. No, not like cloud. No, like, I don't know. It's like points, Like, oh yeah, like today, all this week I lost like 15 points. Since I went through a breakup, like now I gained 20 points. So actually I'm up 5. Does that make sense? Yeah, like Reddit karma. Exactly. Yeah, it's like karma. It's like actual Reddit karma. Exactly. That's exactly what I mean. Like, I'm using it as a metaphor, but that is exactly what I mean.
I don't know what that is. Okay.
Literally. Yeah, it's like brownie points. Yes. I'm sorry, the ads are actually on an automatic timer. I don't even usually pay attention when they're playing. It was a good ult. It really was. I mean, like I said, there are some people that literally, I mean, Felix would be like, guys, I fucking robbed the bank, fucking had 20 real life hostages, not in GTA, crashed the McLaren going 200 miles per hour down the highway, fucking ran over a stray cat on the way, and then I broke my toe, and they're like, oh my god, he broke his toe. Oh my god. I can't believe it. He broke his fucking toe. My poor streamer. Oh my fucking god. I just can't believe it.
I know this is minutes.
Jeez, I can't believe it.
I'm going 2x. It's fine.
I feel like that's any devoted fan base though,
Okay.
which is fine when it is all to do with you. But like I said, it had to.
Hey guys, Arena Stories here, and today I'll be showing you the best possible.
So it wasn't just him. It also had to do with me. Then it was always gonna affect my channel more than his, and not because I don't know why juicers have this thing in their fucking head, like, oh my god, without XQC, what is she gonna fucking do? His name.
But these, I just say like all these comments and these people, they're all unreasonable. Okay, and the way, in my opinion, the way I worded things yesterday, okay, made sure that she wouldn't get hatred from dog shit. Okay, the way that I put things in light, the way that I worded it, the way that I came out, made me thank a lot. I just want to thank one last time and say that, yeah, it's my fault, man. Yeah, things didn't pan out, and it was my fault. I could have done the right thing, and I could have helped, and I could. But the reality is that we had differences that were just never gonna get repaired. And I said a lot of it is my fault. Yeah, I didn't stand up to my family and say boom bang bing and say to them, "Ali, get the fuck out of my house." I didn't tell them to fucking all went and they're all wrong and fuck them over. Okay, yeah, I took my family's side and we just decided to end things. Boom, and it was that is my fault. That's a choice that I make voluntarily. That is a manual choice that I made. Okay, and that doesn't make her look bad or her tank hate. So I don't know why it's all like about her tanking hate here, man.
Name has been blacklisted from my fucking
my
chat
best.
for how many years now? His name and everything he's doing has been off topic from my chat for how many fucking years now? The man, we have dated for like 4.5, 5 years. The dude has hosted me 2 whole times. 2 whole times. When he said, it's unblacklisted right now because what are we talking about? We are literally specifically talking about XQC right now. But for 4 fucking years, we have had to blacklist his name, blacklist question. What time is he waking up? I've announced it so many times on stream. This is not the XQC information booth. Don't fucking ask me. Go ask him. For years.
She's not angry with her host. Don't be rude. I think she's just saying that she gets a lot of juicers that talk shit or whatever. But I didn't forcibly cross-link my channel with hers by force hosting. She's just saying that the residual people isn't like.
For years, I've had to deal with.
It shouldn't
oh
be
my
a
god,
lot,
Felix, this is
but it
happening.
is a lot.
Felix, please, and the juicers just fucking bombarding the channel, and everyone in my channel just being like, "Oh fuck, we can't even talk anymore because there's like 2, 3, 4, 5,000 juicers in here." And then the second that we won't give them the shit that they want, they're gone. Like, I'm just so confused why the juicers have it in their head. Like, oh my god, what is she gonna do when XQC? What am I gonna do when XQC's not there? Fucking chill. Thank God. Like, hopefully now maybe they'll stop fucking asking me the questions that I didn't even know the answers to. Hopefully chill. Yeah.
Yeah, these people are weird, but
that'd be cool.
Kind of have to.
You know what I mean?
Fill the amounts.
Where was I going with that at the beginning? I fucking forgot. I was actually headed somewhere with this fucking.
Be chill.
Yeah, I know it's everywhere. I know it's everywhere, but this is what happens when somebody fucking blindsides you after they've agreed days and days and days to not do it. The career, yeah. So again, I mean, the ways that it would affect me is a little bit of what's happening right now. Everyone in here.
Okay.
I mean, I get it. There's some drama frauds.
Okay. I agreed to delay. I was asking if I could. I agreed to a delay. I said I agreed if I could, but I didn't see a timeline.
Some XQC diehards that are like, oh my god, I must stand up for my king. There are some people that are falling for the tactics that are definitely. It was his fault and you had nothing to do with it and you're just so good. Go on about my fucking channel. You go about yours. It would only affect it could affect my channel more in a negative way than it could ever affect yours more in a negative way. Like, he knew that. I knew that.
It's gonna be hard for a day. I get it.
Plain fucking simple.
It was gonna be hard for a day for sure. I think we can.
So what left me would it be okay for him to say anything? When literally everyone's against him.
Oh, my fucking brain. Who is against him? You know that, okay, you do realize that his track record stands up more than one event. You do realize this, right? Are you aware of that?
Wait, what?
Stands up more than one event. You know that, okay, you do realize that his track record stands up more than one event. You do realize this, right?
Oh yeah, makes sense, yeah.
Are you aware of that?
Yeah, true. I don't show up to things, yeah, it happens.
All of Reddit is not live stream fails. Live stream fails is its own fucking biodome.
Okay. Unfortunately, LSF is so big. The LSF is as big of a part of my community than the residual juicers are part of hers. Does that make sense? I think it's a good comparison and a good by ratio, by amount of influence. I think that the part of LSF that is relevant to my channel is about the same or a decent size and ratio by the juicers to hers. So her devalidating the LSF in here we could devalidate the juices on there. Does that make sense? So that's why I don't agree with this, and I don't
If
agree
he
with
had an
talking about
issue with
this.
it, he should have called those people out and not bring Sammy into it. Exactly. Exactly. There you go. I couldn't agree more.
Okay.
Could not agree more. He missed a whole ass production that Ludwig that Ludwig had already paid for. You know that wasn't his
True.
first time missing it, right?
No, that was.
You're a gold digger mad that the wallet is gone.
Okay, bro.
You're right, guys. Please donate more subs, please, God.
Bro, please.
Please, guys. Use code adept.
Yeah, like I said, this is what I don't like about this is that there's no reason to fucking to double down on the Ludwig shape. Okay, I have a lot of respect for Ludwig, and I'm sorry that I didn't show up. Okay, and I felt bad for Ludwig, and I'm making up to him, and I'm gonna reset my relationship with Ludwig. I think Ludwig clutched up. Ludwig is fantastic, and I fucked up, man. I don't know how many more times I have to apologize. It is what it is.
He's right. Please use code adept. You use on Turtle Beach, Rocket, NordVPN.
Oh, you're right. I misnamed your price. You're right, but I mean I thought that was intended. I thought. Okay.
All the above.
Name Your Price was part of Shit Camp the same way that the last year, the Mogul Money was part of Shit Camp. I think it's the same.
G Fuel. How does this
Well,
affect LeBron's
I'm not
legacy?
lying,
I've
I'm
been
just
asking
saying
myself that all
it's-
day, and I just can't.
We're going in for an
answer.
event at the same time, and there's another one. It's not gonna separate both things.
Who's gonna drive his car, Sag? I'm sure I could think of person A and person B that are dying to get their hands on them. From the examples I had earlier.
Come on, man. Bro, my dad's getting a van that I'm buying him. My mom's getting a Model Y, and my brother has a new car that I bought him. Nobody wants a new race car. Like, I don't know.
He's playing the victim card for self-defense, and sadly it's working. Listen, the only issue that I had with it is that I was involved in it in any fucking way. Because you know what's crazy? He genuinely had his own issues with other people, completely aside from me. And that could have literally been the car that he needed, but instead, of course, just had to throw me into the mix. Just had to do it.
Like I said, there's a lot of reasons why I didn't go to the events. Yes, and I've said this on stream. I've already leaked this. I didn't feel like a lot of chemistry with a lot of people that were going there. And I said I didn't feel comfortable and confident. I was insecure. It was gonna be bad because of me. I said I didn't have any confidence in my own ability to do good. That is part of the mix. Yes, it is.
Zom's
I
gonna have
agree
a
with that.
headache
I
when he
already
goes
said this
live.
I scapegoated it. I think giving reasons and stacking it. Okay, there's a lot of reasons for. Okay, I don't think it's a scapegoat. A scapegoat is whittling down everything to one thing and scapegoating it. Okay, I would say there's a lot of problems. Okay, I felt like leaving my brother at home in a state that he was would have been irresponsible. Okay, there's a lot of other shit. Like I said, it's a big mix.
Chav, you're going wild. You're going wicked. Y'all both sound toxic. Thank you. Thank you so much. Yeah, I'm so toxic for standing up for myself finally. I'm so toxic for talking about all of the fucking publicized bullshit.
Guys,
like,
guys,
you know what's
don't get mad at her for any of this shit, guys. She's allowed to be mad. She's allowed to be mad. Okay, I get it. Okay, I do some of this shit. Okay, I get it. She's
something
upset.
that people love to bring up.
It's fine.
They love to bring it up to like use, like I said, is like the Reddit karma against me. Because I
Okay,
have a lot.
okay. I mean, you didn't have her back, and then called family because it's Sammy, and it sounds shitty. Like I said, I took the hit and I said it's my fault. I took my family's side. Okay, and yes, I was bad. Okay, you call whatever you want. I pussied out. I failed. I didn't do right. That is correct. Okay, in the basis of a relationship, doing the right thing to save the relationship, I did not do that one thing. That is correct. Okay,
Fucking negative
and
Reddit
I'm
comment
okay
that
to
I
take the hate that
100.
comes with.
I don't have good shit because I never fucking do what I'm doing right now. Ever. I don't do it. I don't talk about people when I just no longer fuck with them. I'm talking about this instance with XQC because, like I said, I am so fucking tired of not talking about it. Protecting everything. Being villainized over things that were completely out of my control, had nothing to do with me. Completely. People love to talk about the time that I went on his stream and made him unmute things. And if you don't understand through all of this why I was so fucking mentally brought down and desperate to just get him to listen and relax for 2 seconds, then I don't know what could ever fucking show you. Like, you honestly do not understand contextual clues if you don't understand why I did what I did there.
That day was cooked though. That was absolutely fucking
Because
cooked up.
I don't like the public knowing things. he does when he decides it's all good, it's all dandy.
Well, I do. It was
Right?
it's an old story. We're playing RP, okay, and she said in the past that she doesn't like certain like negative interactions with me and RP, whatever, right? Because I would always be mauled. Whenever I get it, I get mauled. So I would get mauled at Sammy. Yeah, it was dumb. I get mauled at everybody. Okay, I'd get mauled at everybody at RP. Okay, I'm typical at RP. I get fucking mauled. Okay, I'm not gonna sugarcoat it. Okay, I'm a fucking asshole, bro. Dead ass. Okay, I'm a fucking asshole. Okay, and then we had talks over. Okay, that off streaming, I said that you know she was antagonizing me when she'd interact with me. Okay, and then she said no, I'm just doing my job. And then I said okay. And then we'd have talks about that back and forth about you know how we conduct ourselves in RP, whatever. Okay, and then she was like, okay, well next time we'll go through as fast as we can and move on, so we don't have to interact with one another. And I agreed. And then we went to the RP. Okay, she was arresting me, and I felt like I was getting stalled. So I was raging out, and then I played my cards right. Okay, yes, guys, it was weird. Okay, it was weird, but it was RP. Okay, it was weird. Okay, but I acted like I was nice in the game. Okay, I you know, in the game, I was a little bit manipulated, you could say, because I wanted to punch her in the game. So what I did is that I acted nice until she got me to the front of the PD, and then I beat her character up. Okay, yeah, it was fucked, but it's because we agreed to something off stream that you know we need to deal with ourselves. You know, in a more like okay, we don't talk to we don't do whatever. So whenever I beat her up, guys, I'm laughing, but dude, listen. And then she got upset, reasonably so, and then she went into real life, and then because there was a OC like sort of agreement, and I guess I kind of broke it. And
He decided, oh, you know what? Psh, even though I told Sammy a billion times I'm not gonna talk about this shit on my stream, and she warned me, and she asked me, and she negotiated with me not to do this shit to her so many fucking times in the last 2 weeks. I'm up. You know what? What is she gonna do? Stop playing We Were Here with her friends? Stop enjoying her stream? No. So I'm gonna talk about it now. Like, come on. Come the fuck on. He's tanking all the hate? No, he's not. I guarantee you right now, if I come open LSF, I guarantee you the first comment on any of the clips from my channel, there's 3 top clips. 2 of them are from my channel. I guarantee you both top comments are negative about me. Guarantee you. And he knew exactly this is what would happen. He knows that this is exactly what happens to women that go against anyone on fucking LSF.
I mean,
I'm sorry, it's just kind of is that way.
okay, from what I said, what stems from my comments I did on stream, and the way that I put it, I could be wrong about this. Okay, I looked at the comments yesterday. Nobody was against yesterday. I understand that this is partially true. Okay, and that it can get like that. Yesterday, when I talked about it on stream, it was not okay. People were understanding of the situation, and nobody took sides. I mean, nobody threw under the bus. Nobody was against her, man.
Top one is LSF Frog.
Right? It was fine, no?
I was told to touch grass, ended up missing the drama, never again. In the bright side, my in-depth can start the ex-girlfriend podcast now. Even if we still were doing Housewives, it would still be called Housewives. I know you guys probably never watched those reality TV shows, but most of the girls on those shows are divorced and single.
Okay, no problem.
Meow.
Yeah, you were supposed to go to Ludwig's after you made me do it. I'm ready to send you
kind of the
in
whole
the chat
point.
at the same time,
It's like the irony
but
in it.
I'm trying my best to be at the same time. Housewives podcast, yeah. Don't be rude. Well, I'll be rude. I mean, I'm watching it.
Well, all the top comments are jokes, which I actually think is fucking hilarious. The top comments on the other one are jokes as well. Shit Camp is a streamer couple's Grim Reaper. Probably bad take warning, but relationships don't end in a single day. Things were probably weird already when he said he didn't want to go. Oh my god. Ah, yes.
Well, I mean, true.
We are very decisive people that surely knew the relationship. Yeah. No, this guy's got it figured out. I mean, do you really want to go to the same event with your ex right after breakup and having family drama? Or, hear me out. You were already not going for reasons beyond your relationship.
Okay.
You made it very clear many.
Okay, true, but I was still genuinely on the fence, and we had talked about that. Genuinely on the fence. The last day when we broke up was extremely boiled. It was deep fried. Okay, and then that was the breaking point of like, yeah, there's absolutely no shot. That's it.
Many times in.
I understand she was scared that people would say that that it's her fault that I didn't go to the event. I get it. She was scared of taking the hate that people would say, oh, because of the breakup, which is her fault, let's say, right? People were gonna say, he didn't go to the event, we didn't get the content, so we're gonna get mad at her. That was the worry, and that's a reasonable worry. Okay, that was a reasonable worry.
Private, couple times in public. You were already not going.
But that last day, it
Don't give the parasocial juicers any attention. I'm telling you, I might in detail talk about a lot of things because now that it's out there, like I said, it is hard to just decide what I want to do. I have a lot of things that I would love to get off my chest because I'm so fucking tired of being villainized. I'm so fucking tired of the...
Yes, Sammy, you are right. I was not going. You are correct. I was already not going. I think everybody knows this already. Everybody knows it. But a lot of these things were because of some of these problems. It's not... The breakup wasn't the main reason. It ended up being a small thing that made it above. But the events that went before that, in between us and our chemistry, were a big part of it. It was problems like crazy.
The little bits and pieces he has taken here and fucking there. I am so fucking sick of it. A part of me doesn't know if the emotional release would be satisfying, I guess. Like, just to literally talk and get things off my chest. But at the same time, a bigger part of me is like, kind of don't want this fucking on the internet for fucking ever. What is already out there, I don't really have a problem with it being repeated. Felix will probably give context to more things because he'll find a way to just be like, yeah, see, she's not giving context because look at this, guys. Look at it. Like, but I don't know. Historically, I've never really given attention to any drama that I've been through. Can you guys even recall drama that I've been through that I talked about beyond the immediate scope of the drama? Like, the GTA RP shit. People think that we broke up over GTA RP. Did I ever clear up anything? Did I ever clear that up for anyone? Never. CX. Was that drama, though? Me and CX didn't have drama, though. Everyone just tried to say the CX event was something that it wasn't.
That was cringe. These were cringe. People said that.
I did not have drama with Ice, Andy, CX. I never had drama with them.
That was cringe as fuck. I don't know what I don't know what anybody feeds into any of that shit.
I gave the context to what it actually was because for whatever reason people don't watch the VOD.
Yeah, nobody. This everybody's so dumb. It's not cringe. It's content. I mean,
if I were you, I'd point out that expectation.
We're content creators. We made content. The fact that you're still talking about it means it was good content. You're the winner in this. Why do you shut down things that you enjoy watching?
I thought you were roommates.
You watch a shit. It makes you react, be part of things. Literally, that's why you mad about this. That's content, bro.
I don't really give a fuck about most of the people that will continue to associate with him because there's so much that I'm just really not willing to talk about yet. And if people don't have the full image, how do I expect them to know what it is that would keep them from talking to him? I just don't care. I just don't give a fuck.
Wait, what?
And at the end of the day, most of the other streamers siding with him and announced to be willing to...
Huh?
If I were you, I'd point out the expectation of other streamers siding with him and announce to be willing to take the damage. I don't really give a fuck about most of the people that will continue to associate with him because there's so much that I'm just really not willing to talk about yet. And if people don't have the full image, how do I expect them to know what it is that would keep them from talking to him? I just don't care. I just don't give a fuck.
I don't know what it means.
And at the end of the day, there are gonna be some people that just genuinely like him more. And it doesn't matter what I say, for them, whatever he says will be true. So why would I even want to go there and get mixed up? If anything, my life will be easier if most people don't pick one side or the other. And that's not because I need any way in with people. I truly don't. I have real friends outside of stream. I have real friends that I've met through streaming that we have genuine friendship.
Well, I genuinely don't know. I genuinely don't know why anybody would stop talking to me if they knew something. Why would they stop talking to me?
I don't need them to pick sides. I don't want them to pick. Some of them already have.
A lot of people know our problems privately.
You'll see, like, when drama things pop up, you'll see some of these people that you can most likely logically gather I'm friends with just keep their mouths shut because they know that I keep my mouth shut. I don't want them to pick sides. I don't. I know that for some of the people, if they had the full story, they wouldn't. However, I don't know that I would tell most of these people the full story
Yes,
until
yes,
I tell
yes. Relationships are absolutely cooked up. Okay. Sometimes being in relationships is chaotic, and some things that are insane that happens. Then there's differences, and there are fights, and there's arguments, and there's a lot of yelling, and there's a lot of molding. Things go absolutely bonkers sometimes. Yes, that happens. Okay. Yes, there's a lot of that. Okay, but nothing was out of the scope of things that are like, oh my god, people won't talk to this person anymore. I don't think there's a single thing that are out of that scope, because a lot of things we talked privately to our friends about some of these problems, and nobody has stopped talking to anybody. It's not like there's no insane crazy shit like.
the full story. I don't know. I just don't know if I want to. Did other streamers at Shit Camp already know about you guys? No. Nope. None of them.
Wait, what?
No, none of them. I mean, it was obvious. Literally, no one knew me and Felix were broken up. Not even his viewers. You're saying it was obvious, and it just simply was not. Yeah, people have thought me and Felix have been broken up since GTRP.
Incorrect.
Oh yeah, sorry, that one guy knew actually. You're right, that one guy. He knew. I think you should just try and move on. I think maybe you should just keep your you shoulds to yourself. I think you should go look in the mirror and say you should. That's what I think you should do. I think the only time you should be saying you should is when you're looking in the mirror. Talking in your own fucking head. I do not give a fuck what you think I should do. I truly don't. But you know what I think you should do? Use code of death. Thank you very much.
Okay.
I know that there were people speculating like, oh, he must not have gone to Shit Camp because they must have broken up. But like I said, that just literally, and he'll probably deny this because like I said, he word for word admitted that it would be the better scapegoat. Word for word admitted it will be the better scapegoat.
Wait.
He'll deny that the reason he didn't go was already predetermined before we broke up. Things were not as weird, as bad, whatever, that our relationship in any way was keeping him from wanting.
Yes, I feel like she thinks that I didn't talk about this on stream. Maybe she missed it, or maybe she doesn't care, and she shouldn't care because that thing is boring as fuck. Okay, but I had already said on stream that I didn't have chemistry with a lot of people. I didn't even know some of these people. A lot of people that at the event, I didn't even know them, and I said ahead of time that I felt comfortable doing content in a smaller circle if I have to. Something reliable, like Poke and Soda. Something reliable. If all fails and I'm bad at the event, I can make content with Soda and whatever, and I think it's gonna go hard. Okay, and guys, I felt insecure about doing that, and I said I didn't feel comfortable with people that I generally did not know. Okay, that's it.
Like I said, the moment where a lot of shit really blew up was the incident that I talked about. That incident was like, for both of us, a huge moment of being like, fuck, all right, yeah, this is not it. And guess what? He was already not going before that day even happened. He was already not going.
True. And a couple of these things were relationship-based things. That's...
We talked about it earlier. I'm not going to repeat it.
I think that goes without saying. I mean, it's why the breakup isn't the only thing. The relationship and the breakup are part of the reason.
I actually don't agree with the statement that X chose his family. I think that that's even going to be something that is going to be a way that he has tried to depict it. It's simply inaccurate, is how I feel about it. He chose avoidance, and for me, that simply was not enough. It was pure avoidance. Yeah, it was all about the self, and it was all about avoidance. It wasn't about picking one side or the other. And that's why I don't even understand why he's trying to like, I mean, I do get it. I get why he's trying to depict it like that. But it just simply was not that.
There's no game being played here. I'm not playing any cards or being weird about this. Okay? I think avoidance is choosing. Okay? If we have a big problem, and I avoid it. The logical conclusion, it's logical. You know what's gonna happen. It's not. That's still choosing. I still chose. We both chose. Me not doing the right thing meant we were gonna break up, and I didn't do the right thing. And if I put that situation, I would also not do it. So that is choosing by default. That's de facto
So the
choosing.
right call was fuck the family. And the right call, like I explained in the story, would have been.
I take responsibility for
wow,
that. That's my fault.
Everyone is.
And I did
out of
it
fucking
before.
control.
I said it yesterday. I said it today, and I'll say it again today. That is my fault. Yes.
Maybe everyone should chill the fuck out. That was the right answer. You can't shit on family though. In what world is everyone needs to relax shitting on family? In what world is holding everyone accountable to the behavior that they're engaging in shitting on family?
I mean, she did call him psycho and conniving and nuts. I mean,
If anything, I actually think that shows more
past
family.
that point, to be honest.
Dominic Toretto.
Okay.
So X is bad because you chose family. Well, again, I just explained how that statement is extremely inaccurate. It just simply is. That is just simply not how things went down.
Okay. That's pretty much how it went down.
And this guy just keeps saying yummy in the chat. I think he's talking about you guys.
Okay.
Well, we
Okay.
only know how.
Okay. Now if you're just on chat, you can argue with me, against me about this. Okay. You can argue with me about this, but generally, me not doing the right thing and siding with her and being with her is me choosing my family by default. Okay. Yes, I chose. I could have went against them and called them out and have him kicked out and fucking whatever the fuck and go against them. That would have still been choosing. It's why I said I was at a crossroad of making I have to make an action.
Half of the stories, so we can't start concluding who's the bad guy. Felix on his own stream literally already told you. He literally already told you, did he not?
And I'll do what?
And I'm confirming it. This isn't speculation at that point. It just simply is part of the facts.
Okay.
Now, you...
The shit got so cooked, and Chad knows about this because I hinted at it, okay? Because I was so mauled about it. It got so bad to a point after I bought this house and I thought I was gonna move in, and then people were moving out, being kicked out, feeling not included. I literally thought about buying a secondary house